God save the state of Texas and this honorable court.
Thank you. Please be seated. Welcome, everyone. Just due to some logistical difficulties, we're going to start with the second case first, Texas Department of Insurance versus Sam Thomas. Both sides present and ready.
Yes, sir. Yes, Your Honor. Cole Wilson, the Texas Department of Insurance.
Make sure you focus on the jurisdictional issue that has come up about whether this case, if it's not in our exclusive jurisdiction, whether we have it, what do we do with it if it's not? I don't know if you've read the Kelly versus Humunga decision from the Texas Supreme Court last week, but the gist of it is that we have jurisdiction of cases within our, and my colleagues can correct me, jurisdiction of cases within our exclusive jurisdiction or transferred to us by the Supreme Court in part of equalization transfers, but not otherwise. And so, since this is certainly at least a large part of Chapter 21 case, that's not in our exclusive jurisdiction. So we need your help on figuring that out. And you can, if you're not ready to do that today, we can do that post-submission. All right. So let's see. Mr. Wilson going first?
Yes, Your Honor.
You may proceed.
Thank you, Mr. Chief Justice. May it please the court. Thomas's state law claims under Chapter 21 of the Labor Code all fail in our evidentiary challenge because he failed to submit evidence disputing the department's lawful reason for terminating his employment, that he abandoned his job in violation of agency policy. He says this point is disputed because he disagrees with it, but the conclusory assertion in his affidavit is not competent evidence. As to the ADA and FMLA claims for which this court has jurisdiction, Texas has not waived its sovereign immunity, which extends to the department, nor did Congress validly abrogate that immunity for claims under Title I of the ADA or the FMLA's self-care provisions. This point is obvious enough that Thomas does not try to defend the trial court's decision on these grounds. Rather, he argues that the trial court denied a jurisdictional challenge to official capacity claims against named government officials who share the same sovereign immunity as the department.
So FMLA is not a part of Chapter 21, correct?
That is correct, Mr. Chief Justice.
Everything else is a part of chapter, disabilities, age, race, religion, sexual harassment, that's all part of Chapter 21.
In part, Mr. Chief Justice, Thomas also brings ADA claims, which are federal claims that are not part of Chapter 21, although they share elements in common given that he's pursuing a circumstantial case under the McDonnell-Douglas framework. And so there's an element shared in common. And if this court wrote an opinion explaining that Thomas, for example, he was not an otherwise qualified employee on a prima facie case, then ultimately, whether this court found that it did not have jurisdiction over the remaining Chapter 21 claims, then at least that claim could be conclusively resolved under law of the case.
But all of these claims are included within one matter, and I believe our jurisdictional statute speaks to a matter. And so when we're looking at whether the matter includes a claim that does fall within our exclusive jurisdiction, it's your position that the matter does include at least one claim that falls within our exclusive jurisdiction.
That's correct, Justice Phillips.
Okay, thank you.
So Thomas argues that he also raised official capacity claims, but he doesn't explicitly mention that he did in his amended petition. So the little we know about those claims are what he mentioned in his subsequent briefing in response to our jurisdictional challenge, where he clarified he was bringing an ultra vires challenge, both to the federal and state law claims. The trial court explained that Mr. Thomas's ultra-virus challenge to the official capacity claims against Ms. Frederick, Ms. Paul, and Mr. Walker could not go forward. It was inapplicable, but that the same challenge could provide for a waiver to sovereign immunity against the department. The problem is that one cannot bring an ultra-virus challenge to a government agency. It can only be brought against individuals. Another way that the
But-
court...
Ultravirus is not a magic card that overcomes jurisdictional problems. Ultravirus is a government official had no legal authority whatsoever. And these people, your clients, clearly had legal authority to manage employees at the Texas Department of Insurance, right?
That's correct.
So what was the argument below that they were acting without legal authority? Because it's not enough just to be wrong. They make the wrong call. It's got to be they have no legal authority to make a decision.
That's correct, Mr. Chief Justice, and that's what the Supreme Court of Texas explained in Hall against McRaven. As I understand Thomas to be arguing, a conflict or an erroneous interpretation by the government official that conflicts with some other collateral law, for example here the ADA or FMLA, he suggests is an ultravirus act. But I think that the Supreme Court's jurisprudence here is clear that it has to conflict with the enabling authority that permits the government official to act in the first place. So there is not an ultravirus challenge in this case.
Right, this is just a lawsuit against the department.
That's correct. And while it's true that a claim against an official capacity government official is against the entity and not those officials themselves, Thomas clarified that he was only bringing an ultravirus challenge to the extent he was bringing an official capacity claim at all. And our Supreme Court clarified in Franca against Velasquez that that is the one instance in which an official capacity claim is not against the entity, but against those individuals to bring them in compliance with the entity's enabling authority. Turning to some of the overlap with the FMLA claim and the prima facie elements here, Thomas also discusses how he took continuous FMLA almost a year and a half prior to the Adverse Employment Act that he focuses on. And even if this court finds that the official capacity claims still exist below, but they were not part of this appeal, then explaining that the time between that act and the Adverse Employment Act here, his termination in September of 2021, is too great to provide for an inference of discrimination or retaliation, then that would also resolve that claim upon remand, regardless of whether the court agrees with us that those claims still exist here. As for Thomas's state...
This is the first time I've ever heard of self-care claims under FMLA. Do you get 14 weeks for being sick under a self-care exception? How does that work?
The FMLA provides, as I understand it, the same amount of leave regardless of you're caring for your own injury or disability or harm, or you're caring for a spouse, a dependent, and you're caring for that other person. The distinction matters because in the case of Coleman against Court of Appeals of Maryland, the United States Supreme Court found that Congress had only validly abrogated state sovereign immunity for the claims involving care of another and not self-care claims. And that's because under Section 5 of the 14th Amendment, Congress had only provided for that valid abrogation by showing a state historical practice of discrimination with respect to family care claims and not self-care claims. But Thomas here brings a self-care claim. He had taken continuous FMLA and then intermittent leave of 2 hours each day for a shortened schedule to care for himself after he was recovering from a prostate cancer diagnosis and treatment. So the easiest way to resolve Thomas's state law claims, if the court finds that it can do so, pursuant to its jurisdiction over the ADA and FMLA claims that are part of the same matter, is to focus on the adverse employment acts that he alleges. He focuses on 3 separate things. Mr. Frederick's workplace comments that were critical of him, but criticism of an employee cannot be an adverse employment action. an August 2nd, 2021 memorandum that was disciplining him, but that cannot be an adverse employment act because he does not dispute that there were grounds for that discipline, colorable grounds at the least. He stipulates and even appears to agree that he was unwilling or unable to perform some of the tasks that were assigned to him, which is the reason for the discipline.
And these are the training functions, right?
That is correct, Justice Ferris. This is the training other examiners function. And although Thomas focuses on arguing that this was not an essential function of his job and therefore cannot be a reason for showing he was not otherwise qualified, the Barber case, which is a Fifth Circuit case which can be relied on as persuasive authority, showed that any task that bears more than the marginal relationship to the job is an essential function. Additionally, Title 29 CFR Section 1630.2 N3II, which is an ADA regulation for employment claims, explains that a job description for a posting for that job is evidence of the job's essential functions. And if the court turns to our appendix, particularly tab 2, we have that job description, the general description for which says training and supervising other examiners is some of the work that is involved in the position that Thomas held as Financial Examiner 5. As to Thomas's termination at the end of September 2021, he claims that he did not abandon his job, but he only offers conclusory assertions in paragraphs 25, 26, and 27 of his affidavit, which are not competent evidence, and the Chief Justice explained that in passing in the Arkoma Basin decision, explaining that a statement in an affidavit that doesn't provide the underlying reasons and support that inference is conclusory. And here in those paragraphs, Thomas states that the agency did not comply with its own procedures. He doesn't mention what those procedures were. He doesn't mention how the agency allegedly failed to comply. And so all we're left with is the department's valid reason for discharging him.
What do you make of Mr. Thomas's arguments that what you're essentially doing is requiring us to get too deep into the merits at this juncture? Is there any, is that correct? Is that way off base under our governing precedent here?
Well, I understand that that would be correct as to a pleadings challenge, but not an evidentiary challenge, which is treated the same as a summary judgment motion. And here, the trial court effectively denied our evidentiary challenge by declining or neglecting to rule on it. But as the Supreme Court of Texas explained in Alamo Heights, when a government defendant raises a evidentiary jurisdictional challenge, courts are not free to disregard that challenge and focus only on the pleadings. The court must go beyond the pleadings to analyze whether jurisdiction exists on that evidentiary challenge. Now, even if the court disagrees with everything we've said as to the ultimate elements of Thomas's Chapter 21 claims, we still win because he failed to establish a prima facie case. For his retaliation claim, all he offers in the way of protected activity is in paragraphs 13 and 14 of his affidavit, where he references discussions for disability accommodations. His failure to describe that he ever raised the specter of discrimination means he didn't actually engage in protected activity, because he did not complain of activity that Chapter 21 or Title 7 of the Civil Rights Act federally prohibits. Additionally, he doesn't say when those events occurred, so he couldn't establish causation. As for his disability discrimination and failure to accommodate claim, although we of course concede that cancer is a disability, Thomas simply neglected to develop the record about whether he was still suffering from cancer, how long his diagnosis and his treatment following his continuous FMLA had lasted. All we have here on this appeal on the record is that he said he had medical limitations that his doctor provided to the department. We don't know what they were on this record before the court.
How specific does a person like Thomas need to be? They're obviously recovering from very traumatic cancer scare. It's a very personal nature. Like, how much does the employer actually have to know in these types of circumstances?
Not much, Justice Ferris.
Okay.
But the issue here is that he simply failed to develop the record. He doesn't even say what that disability was that caused the medical limitations for which he said he couldn't perform certain functions. Now, Thomas does offer that the argument that he was constructively discharged as a way of trying to show that the department's termination decision was pretextual. But as a preliminary matter, constructive discharge is only a way of establishing the prima facie case, not disputing an employer's lawful reason for the Adverse Employment Act. But Thomas also fails to show he was constructively discharged, which is a greater showing than even a hostile work environment claim. The Fifth Circuit explained, and the Third Court of Appeals here in Austin has borrowed these same 6 factors in Gardner against Abbott for how to decide whether or not an employee has even raised constructive discharge. 1, demotion. Thomas does not claim he was demoted. 2, reduction in salary, which he also does not claim. Reduction in job responsibilities. Here we have the opposite. Thomas wanted a reduction in his job responsibilities. 4th, a reassignment to menial work. Again, here we have the inverse. Thomas complained that his work was too complex. He wanted an easier set of work assignments. 5th, badgering, harassment, and humiliation, which more on this in a moment. And 6th, offers of early retirement that would make the employee worse off regardless of whether they accepted. And here the memorandum terminating Thomas shows that he was never given a devil's choice between worse off retirement or returning, but even after he violated agency policy and was able to come back, he was still offered the chance to return to the office and continue his employment, not on worse conditions, but the same. As to the humiliation and claimed harassment, the plaintiff in the Gardner case had 13 separate instances of alleged harassment, and even that was not enough, according to the Third Court of Appeals. And here we have far fewer. If the court has no further questions, I'll reserve my remaining time for rebuttal.
Thank you, Mr. Wilson. Mr. Downey.
Yes, thank you, Justice. I think the best way to approach this is to start from square one, which is the Texas Commission on Human Rights Act claims under the Texas Labor Code. It's very clear that sovereign immunity is waived in the event that basic elements of the claim have been shown in response to a plea to the jurisdiction. In this particular case, I am not entirely sure how the state is claiming that Mr. Thomas was not either A, disabled, or B, that they didn't know about it, when in fact there was very clear communications, and it's clearly stated in the record, discussions between Mr. Thomas and the folks at TDI discussing his need for an accommodation, namely, which was actually granted by TDI, which was to reduce his work hours and to limit his duties and responsibilities.
The problem is we almost certainly can't write anything about the TCHRA. We're an odd court. It's an odd bird. If you bring your, TCHRA is basically the same as Title VII. One's a state statute, one's a federal statute. The legislature in its wisdom says suits against the state, we have no jurisdiction of Chapter 21 claims, TCHRA, but we do have jurisdiction of Title VII under the Federal Act. Now, so I think it would be very unlikely we would write an opinion on the merits of the TCHRA since we have no jurisdiction of it. I'm not sure what you do when the two claims are exactly the same.
Which they are in this particular case. They are nearly identical.
Well, would we have
Actually,
right.
I take that back. We're in this particular situation, we are not claiming under Title VII, we're claiming under the Americans with Disabilities Act.
Would we have jurisdiction to write if it's within the same matter as a claim that falls within our exclusive jurisdiction?
I would think so. That
Sure.
And I think that that's provided for within within the Texas Labor Code, Chapter 21.
Okay.
And so consequently, I do believe that, the defenses that they have raised or to claim that somehow sovereign immunity applies, it doesn't apply in this situation. I think we've more than adequately demonstrated the facts to support those claims. As far as the ADA and FMLA, it's a little odd dealing with this in a state court level, to be honest with you. In my 30 years of practice, it's probably the second time that we've dealt with it. However, it's very clear from the case law here that what the judge did was the judge found that, in fact, Ms. Paul, and this is on the fourth page of the opinion, She went through the listing and specifically stated the ministerial duties that these individuals failed to execute within their official capacities, namely, they failed to engage in the interactive process under the FMLA, or ADA and FMLA. They interfered with the ADA and FMLA leave that was granted. They retaliated based on, or they potentially retaliated based on FMLA assigning more work than at least one could perform under his or her approved FMLA schedules. Those are all clearly ministerial acts. So consequently, again, the case law is pretty clear that sovereign immunity is not going to absolutely apply to those situations, as the district court judge rightfully decided.
As to the individuals, though, right?
In their official capacities, yes.
Right. And that's what confused me, honestly, in reading the briefs. I felt like I was reading two different appeals. Because the only appellant is TDI, right?
Correct.
So I can't figure out for the life of me why we're talking so much about the individual actors and whether they were acting in their official capacity and had a ministerial duty, because what does that have to do with any claim against TDI?
Because the sovereign immunity TDI is not able to apply sovereign immunity to those claims based on the fact that there are ministerial duties being carried out by officials in their official functions.
Well, wouldn't those people have to be parties then?
Well, and the thing is I believe that the judge has, the judge has said, yes, they are removed as individuals, but they are not removed as individuals in their official capacities. I think that was parsed out within the order very clearly, because she has clearly stated that the actions taken by these individuals were in their official capacities.
Right, but how does that make the claim against TDI?
Because it waives the sovereign immunity issue, or it overcomes the sovereign immunity issue.
It does for those individual acting in their official capacities, but how does it for the entity itself?
The case law is clear that the causes of action, or the court still has remedies with regard to TDI to ensure and to enjoin and to take other equitable actions against TDI for the actions that were in violation of their ministerial duties. So TDI is still liable for their actions. They were acting within the course and scope of their job. So as an employer, if an employee is acting within the course and scope of the job, with the exception of maybe sexual harassment and maybe a couple other individual liability situations, the employer is responsible. And that's what we're talking about here, is that the employer is responsible for these actions of these individuals.
And I recognize it gets difficult in the ultra-virus context, because I recognize it's confusing in that you're suing the individuals in their individual capacity, but your remedies are really, it's not clean, because your remedies really ends up against the entity.
Correct.
But yet we've got case after case after case saying in an ultra-virus situation you can't sue the entity. It doesn't waive their sovereign immunity.
Well, I think that's where the case law comes down to say is, in fact, that you can continue a cause of action against the entity for the actions of these individuals that violated their ministerial duties under these statutes, and that sovereign immunity is waived with regard to that. So I think
So just taking, for example, I'm just trying to think of different ultra-virus claims, Hall versus McRaven. You're saying Hall should have been able to pursue a case against the University of Texas?
With the actions of the official capacity where there's a violation of their ministerial duties. And again, this is another factor, is the ministerial duties. It's not just a discretionary duty versus a ministerial duty. In this case, there was a ministerial duty for these individuals to follow the application of the law with regard to the ADA by providing reasonable accommodation, follow the law with regard to the FMLA, and granting and allowing for the leave of absence and the intermittent leave that was requested and approved by the state. So the state actually approved, and it says FMLA leave. So the fact is that the state is actually recognizing the application of the FMLA in the employment setting to this individual, and by the violation in their official capacities of that rule, there should be liability against the state.
Can you point me
And
to
it
a,
should,
can you point us to a case on an appeal where they've been, in this situation, has been allowed to go seek direct action against the entity rather than the individual actors?
I believe I've cited a couple in my briefing, and to be honest with you, I apologize, I'm completely drawing a blank on what those cases are, but I'm
But
happy
it's
to.
just the cases in
draw
your
them.
briefing?
Yes.
Okay, thanks.
So help me, I know you haven't necessarily read this new opinion, but, so treat this as a hypothetical. So assume our court hypothetically has jurisdiction of TCHRA employment discrimination cases. Exclusive. Nobody else has it. And assume our court does not have jurisdiction of Title VII federal law claims. And the two are assumed, as you're allowed to do, you can plead both. So appeal comes to us, what do we do with it?
Well, I think that the traditional case law, as counsel has pointed out, so the way that the case law had traditionally been treated is to say if a plea to the jurisdiction is brought where sovereign immunity is raised as the defense by the state, which is exactly the situation in this case, that it is then that the plea to the jurisdiction is then actually treated more like a motion for summary judgment. And that's what they're saying then. That's why they're going back to, hey, what does the record show as far as the evidentiary factors and why they're talking about prima facie cases and pretext and all these things. So that's why they're deferring back to these things, is because what the motion, or for the plea to the jurisdiction is treated as then is a motion for summary judgment, which, as we know, the standards for motion for summary judgment are, is there any evidence of each of the elements, or is there a material fact shown for each of the elements of the claims? And in this case, our position is absolutely. And, you know, this is where we get into, is there a disability? Was he qualified for the position? And was there a pretextual action taken by the employer in the case of the straightforward discrimination?
So let's say you do both Chapter 21 and Title VII cases. You win or lose on both of them. Would you prefer a system in which we split that case on appeal and we get the Title VII case and Third Court of Appeals or another Court of Appeals gets the Chapter 21 case? Or
No, I think that the jurisdiction would all lie within the same court. I don't think that there's I see no basis in the case law to be splitting these cases out.
would you object if one court or the other said, we'll take it?
No, I don't think that there would be a basis for that.
Don't it? No, you're supposed to say, that depends on who the court is, right?
Well, it probably does depend on who the court is. But, Your Honor, looking at the situation to say, again, the split between the state and the federal, yes, I'm surprised with the fact that we pled federal claims.
Sure.
I get removed all the time. And so I'm up in federal court, and there's never any real question as to
Right.
jurisdiction.
They have
The fact is-
pendant jurisdiction. and-
Exactly. So I believe that Your Honors have the authority to rule on all of these cases. And the thing is that I think the case law is also very clear to say that, you know, you can pull from federal case law to apply it to state law where they have similar claims. And in this particular situation, I think ADA and Chapter 21, with regard to disability discrimination and reasonable accommodation, are nearly identical.
And before we get too far down into your time, could you respond to the allegation that the accommodations that your client requested here were not specific enough, were conclusory, and that they also dealt with basically essential functions of the job?
Sure, absolutely. With regard to the essential functions, I think it's very simple that we look at the record at page 164, and there's a job description here. And it clearly says essential functions of the job. and it lists out under a number of bullet points the exact essential functions of the job. And the closest essential function of the job that, with what they're claiming is he did not train, he was unable to train individuals because he received a huge assignment otherwise, on top of the fact that of his limitations on his time due to the approved FMLA intermittent leave that he was receiving.
So is there evidence in the record that, of kind of how those two are related? Like, is a training so long that it can't be accommodated with his limited hours, or what is it specifically about the training that?
Yeah, the interesting thing on that is we would probably have to get into that if he actually had been assigned any training. But he went to the manager and said, I don't want to do training. The manager said, fine, you don't have to do training. So in this situation, it's kind of like, well, wait, is an essential function of the job that he was supposed to be doing it and he didn't. It's not a matter of he didn't do something that he was assigned to do. He simply said, hey, my limitations are limiting the amount of time that I can work in a particular day, and that limits my ability to work on this major assignment that you've given to me and to also do this training. I mean, he's already, the record does clearly state in the affidavit that we submitted where he talks about very clearly that he said at the point that he was given this huge project, he goes, wait, this project is bigger than even just me, and requested numerous times to say, hey, I need more help on this project. They refused to give it to him. That doesn't even consider the fact that on top of saying, hey, wait, this is a huge project, I can't accomplish this, and the facts are very specific within his affidavit to discuss this. This is why I say conclusory. I'm not too sure where they're coming up with that argument. But he clearly says that, hey, this project is too big for me. On top of that, this project is really too big for me, given the fact that I'm continuing on FMLA intermittent leave that has been approved by the state. I have been approved for limited, I believe it was 6 hours of work on a daily basis. You've given me this huge project that's going to take way more than 6 hours a day to accomplish it.
Well, was his specific accommodation like you never have to train anyone, period, or
No.
this particular?
No.
Okay.
This was a very limited situation. This was a limited situation to the time period, and I think we spelled that out within the affidavit. It was a particular group of new investigators that were coming in, and he simply said, hey, can I, because of my limitations on my time, and I've got plenty of work to do otherwise, can I be kind of let off of doing this job? And they said, and it was never assigned to him. So that's another argument to say, in addition to the fact that it's not showing up on the job description as an essential function to do training, the fact of the matter is that he was never asked to do the training because he requested not to do it, and so they didn't assign it to him. So he's not refusing to do some job that he's been assigned to do. It is a matter of, it's not an essential function, we don't believe, based on the job description that they submitted in the record, and then B, like I said, it wasn't ever assigned to him. So obviously it wasn't too essential to his job if he was able to still do his job, and not do that particular responsibility.
And if I could also ask about the reprimand memorandum, is it conceded that the reprimand memorandum was justified, and that was, help me with that.
Well, the interesting thing about no, it is, actually it's not conceded. As we discussed in here, the initial reprimand email that was sent to him said, do not participate in activities that are unnecessary to his job. And he's sitting here saying, look, I'm asking for clarification on a couple of the responsibilities that you've assigned to me with regard to this particular project. In particular, I believe there was some meetings with, I can't remember, examiners or somebody like that were supposed to be taking place on a bi-weekly matter, which was a unique situation to that particular project. And so he was simply asking for clarification, and the response was, do not participate in unnecessary conversations. So yes, we are absolutely disputing. We're saying that action by them was, not only retaliatory, but evidence of at least a negative attitude towards his accommodation needs and his disability needs and his limitations. Because they're just coming after him and not answering a simple question that he's asked about how to do his job on a day-to-day basis. So yes, we are disputing that. And I think too that it's clear in the record that there's a memo that's put in as the termination of employment. I believe it's record page 168 through 170, where there's a specific discussion about this fact that that he is absolutely disputing this fact, and that he is that Mr. Thomas has actually raised. Apologize. That he has actually raised a complaint with not only his original ombudsman HR person, a gentleman by the name of Chris Pope, but then he subsequently raised the complaint, a similar complaint again, discussed very clearly again in detail in our affidavit with. He first reached out to Curtis Polk to discuss the matter. Then he reached out to Cynthia Oliver, the Deputy Commissioner, and Deputy Commissioner Jamie Walker, to raise his complaints of discrimination and the issues that he was having with Mr. Frederick and Ms. Paul, who were the ones that were assigning him work, and had submitted this memo to him saying no unnecessary discussions. So, and then on top of that, it's in the record as well that there was an issue and a complaint made to the General Counsel of TDI, Robert Rucker, discussing exactly that again, these details of, hey, I feel like I'm being discriminated against, I feel like I'm being harassed. So consequently, again, when we get into the issue of retaliation, their claims that he didn't make a complaint is beyond us.
Thank you, Mr. Downey. Any
Thank you
more
so much.
further questions? Thank you, sir. Mr. Wilson, 5 minutes.
Thank you, Mr. Chief Justice. If the court would like supplemental briefing on the jurisdictional question, I'd be happy to provide it, and I'd
Yeah,
appreciate the
it's-
opportunity.
Well, we didn't know it was coming out either, but it's two issues. Number one, do we have jurisdiction of FMLA as well as Chapter 21? I think FMLA is not excluded. Chapter 21 is, but if there's some way we have jurisdiction of both or not, and if we don't have jurisdiction of both, what do we do with this case? Thank you.
But to answer the court's hypothetical, I would object to the court severing the case or refusing to exercise jurisdiction if it could over part of the case. And it doesn't seem prudent to sever claims that
Are identical.
Right,
That
so
are identical.
you would say that if there's one claim within our exclusive jurisdiction, within the matter, we have jurisdiction over the matter.
That is exactly right, Justice Ferris. That's
So
what we
if
would
you can
encourage.
get us some authoritative cases from your department, that'd be helpful.
I would love the opportunity. As to Thomas's suggestion about removal, of course, removal would not have happened because a government entity waives its sovereign immunity challenge to jurisdiction under a 12b1 in federal court if it removes the case to federal court. So that, in some part, provides some context for why that decision wasn't made. As to the argument from my friend about whether or not Thomas was assigned to train other examiners, in paragraph 7 of his affidavit, he explicitly says he was assigned to train other examiners by Ms. Paul. Quote, Ms. Paul told me I would also need to assist in training newly hired examiners, in spite of my request to be exempt from such training responsibilities given my medical limitations. Now, it's true that the job description says there's a separate section for essential functions, but there's also a basic description. The essential functions includes other work as assigned. And the basic description explains that this is work involved for a chief examiner 5. That was assigned to Mr. Thomas, and he failed or was unable to perform that function, and therefore he was not an otherwise qualified employee. As to the case of Halgins-McRaven, I think it is important to at least understand what that case is talking about. There, the plaintiff alleged that the defendant's interpretation of FERPA, federal privacy law for educational privacy of students, was wrong and thus ultra vires. but our Supreme Court disagreed, explaining that McGraven's enabling authority directed him to decide whether or not the regents of the UT system could review information protected by FERPA, but did not constrain his discretion. And even if his interpretation of that federal law was clearly erroneous, it is still not ultra-virus under our Supreme Court's jurisprudence. Ultimately, if this court were to write an opinion agreeing with the points over which it has jurisdiction and trying to cover as much ground for the ADA and FMLA claims that would also share some commonality with the Chapter 21 claims, then ultimately we could resolve all, or most if not all, of the claims that are involved on this appeal, even though Mr. Thomas's counsel claims that some of them are still in the trial court. One other thing bears mention, an ultra-virus challenge, even where it's permitted, similar to an ex parte Young challenge, is limited to prospective injunctive relief and not monetary damages. So even assuming Thomas had a viable claim, and even assuming he could bring such a challenge, he would be limited to reinstatement. And reinstatement is only available where it's feasible. And if the department showed upon some hypothetical remand that it was infeasible, Thomas would not have an alternative remedy for front pay, which is monetary damages, even if equitable. So he would be left with nothing. We ask this court to reverse the decision below and enter judgment for the department. Thank you.
Thank you, Mr. Wilson. If you all could try to get those in for us within a couple of weeks, that'd be very helpful. So the court will take a brief recess, back 7 minutes.
All rise.